The gates closed at 7:43 on a Friday morning in October, and I want you to understand something before I tell you what was behind them. The gates were 12 feet tall, black wrought iron with gold tipped finials, and a stone pillar on each side that my husband had chosen personally from a catalog of estate ironwork that cost more than most people's cars. They opened with a remote, with a keypad, and with a biometric scanner that read the handprint of everyone who had been registered to enter. They were the gates of a property at 4417 Meridian Drive in the Westbrook Estates neighborhood of Hartford, Connecticut. A 6-bedroom, 7-bathroom, 8,000 square foot colonial revival with a 4-car garage, a heated pool, a guest cottage, and grounds maintained by a landscaping team that came every Thursday. My husband had bought that property 14 months ago. He had told me it was a corporate asset, a client entertainment property, a place where he could host investors and business partners in the kind of setting that generated the kind of relationship that generated the kind of return that generated the kind of life we were living. I had believed him, not because I was naive, because I was busy. Because I had my own work and my own practice and my own clients and my own life that I was living alongside the marriage. And because when your husband is a man who has always had explanations and the explanations have always been sufficient, you build a practice of accepting sufficient. I was very good at that practice. I was done with it on the morning the gates closed. My name is Victoria Grace Ashford Mensah. I am 38 years old. I am a corporate attorney with my own practice, Ashford Legal Group, with 11 attorneys and a client list that generates $7 million in annual revenue. I have been married to Raymond Kweku Mensah for 9 years. Raymond is the founder and CEO of Mensah Development Group, a real estate development company with a portfolio valued, at the time of the morning the gates closed, at approximately $400 million. I am also the person whose name is on 41% of that portfolio. Not because Raymond gave it to me, because I built it with him, and because I am an attorney and I understand what names on documents mean, and because in 9 years of marriage, I had been paying attention to the documents even when I had not been paying attention to everything else. The gates closed because I closed them. And what happened when they were closed is the reason you are here tonight. Before the gates, I need to take you to the beginning, because the beginning is where the pattern started, and because patterns, once you see them clearly, are the most useful thing you will ever find in the ruins of something you thought was built differently. Raymond and I met 12 years ago at a real estate closing. I was the attorney for the seller. He was the buyer, representing himself, which was unusual and which I had noted in the specific professional way that you note things that are out of the ordinary pattern of a transaction. He was 32, already operating a development company that had completed 4 projects, and he had the quality that I have spent years trying to describe accurately, a specific combination of vision and practicality, the ability to see what a property could become and simultaneously understand exactly what it would cost to get there. I found that combination attractive. I should have paid more attention to what it meant when applied to relationships rather than real estate. We dated for 2 years. We were good together in the way that two ambitious people are good together when they are both building things and they understand each other's building because they are made of the same material. He understood why I worked at 11 at night. I understood why he drove 3 hours to walk a property at 6 in the morning. We did not require each other to stop being what we were in order to be together, which felt like the definition of a good partnership. We married in September, 9 years ago, at a venue in Westchester that Raymond had actually developed, which felt poetic at the time and which I now understand was the first indication of a quality he has that I did not see clearly until much later. Raymond does not separate his professional interests from his personal ones. He finds synergies. He layers things. He builds structures that serve multiple purposes simultaneously, and he is very good at making each purpose appear to be the primary one. The first years of the marriage were good. We built together in the literal sense. His company grew and my practice grew, and we were two people with aligned ambitions moving in the same direction, and finding that the alignment produced momentum. By year 3, Mensa Development Group had 15 projects in its portfolio, and I had grown Ashford Legal Group from 3 attorneys to 7. We bought our primary residence, a townhouse in the West End of Hartford that I had selected and that I loved, and we talked about children in the specific future tense way that two people who are building things talk about children, meaning it was always 3 years away and 3 years away for 5 years. At year 4, something shifted. I will describe it the same way I described similar shifts in other stories I have told, as a change in the texture of the marriage that was not dramatic and was not nameable, and was the kind of thing that a busy person can file under the ordinary friction of two ambitious lives running alongside each other. Raymond traveled more. He was less available in the evenings. He was sometimes distracted in the specific way that people are distracted when they are managing something they are not discussing. I filed it under business pressure. He was expanding. The portfolio was growing. There were investor relationships and lender relationships and the specific demands of a development business at the stage where it is transitioning from a small company to a mid-sized one, which is the stage that breaks most businesses and which requires the founder to be in many places simultaneously. I told myself this. I believed this. I kept working. At year 6, I found the first thing, not the mansion. Something smaller. A hotel charge on a credit card statement that I processed because I handle our personal finances. I am an attorney. I handle documents. This is not unusual. And that was from a hotel in Boston on a weekend when Raymond had told me he was at a conference in Chicago. I sat with that for a long time. Then I did what I am about to describe, which is the thing that, when I look back at the 6 years between that hotel charge and the morning the gates closed, I understand was the most important professional decision I made in that period. More important than any case I took or any client I signed or any expansion of my practice. I called my law partner, a woman named Dr. Amara Osai-Bonsu, who had been with me since the beginning of Ashford Legal Group and who is, in addition to being one of the sharpest legal minds I know, The kind of person who receives information of this magnitude without performing an emotion about it, and who immediately begins thinking about what to do with what she has received. I said, Amara, I need to talk to you about something that is not about the firm. She said, come to my office and close the door. I went to her office and closed the door, and I told her about the hotel charge. She listened. Then she said, what do you want to do? I said, I want to understand the full picture before I do anything. She said, that is the correct instinct. What do you need? I said, I need to understand what I own and what I don't own, and I need to know the answer to that question before Raymond knows that I'm asking it. She said, that is also correct. Let's start with the documents. What Amara and I built in the 3 years between the hotel charge and the morning of the gates is a story about the specific power of 2 attorneys who understand that information is the only currency that matters in a dispute involving significant assets and a person who believes he is the most sophisticated person in any room he enters. Raymond is sophisticated. I want to say that because accuracy requires it. He is not careless. He does not leave things lying around. He has, over 11 years of building a $400 million portfolio, developed the habits of a man who understands that what is documented is what is real, and what is not documented exists in a space that can be managed. What he had not accounted for was being married to an attorney who had been quietly, carefully, and completely examining every document with his name on it for 3 years. Let me tell you what we found. The 41% ownership interest that I described at the beginning of this story is the correct number. I had been involved in the legal structuring of Mensa Development Group from the early years, and the ownership structure of the various entities that comprised the portfolio was something I knew in detail because I had helped draft it. What Raymond did not know was that in year 5 of our marriage, when I had begun to feel the texture shift that I was filing under business pressure, I had quietly, in the course of a routine portfolio review that I conducted annually as the company's founding attorney, documented every ownership interest, every entity structure, every operating agreement, and every property holding in a way that was thorough enough to be used for something more specific than annual review. I had been doing annual reviews since year 2. I had 6 years of documentation before the hotel charge ever appeared. What the 3 years of post-hotel charge investigation produced, with Amara's help, was a complete picture of what Raymond had been building in the spaces he believed I was not looking at. The mansion at 4417 Meridian Drive was the centerpiece. He had purchased it 14 months before the morning of the gates through a subsidiary of Mensa Development Group called MDG Holdings III, which was a legitimate entity in the portfolio that I had reviewed and that I had access to. The purchase price was $4,200,000. The property had been furnished and renovated at an additional cost of approximately $800,000. The total investment in the property was $5 million. He had told me it was a corporate entertainment asset. Her name was Celeste Margox Fontaine. She was 31 years old. She was an interior designer who had worked on 2 of Mensa Development Group's commercial projects. She had been in a relationship with Raymond for approximately 3 years, which meant the relationship had begun approximately 1 year after the hotel charge that I had found, or possibly before the hotel charge, and the hotel charge was simply the first evidence that surfaced. Celeste Fontaine had been living in the mansion at 4417 Meridian Drive for 11 months. She was not on the property title. She was not on the operating agreement for MDG Holdings III. She had no legal connection to the property whatsoever. She was living in a $5 million corporate asset as a personal guest of the company's founder, who was billing the property's operating costs, the maintenance, the landscaping team, the utilities, the household staff, to the corporate entity, which meant those costs were being treated as business expenses, which meant they were being funded by the company's revenue, which meant they were being funded in part by the 41% interest of the company's co-owner, which was me. I was, in the most precise and accurate legal sense, partially funding my husband's mistress's mansion. I want you to sit with that. I sat with it for 3 months, which is how long it took Amara and me to verify every element of the picture before we were certain that the picture was complete. At the end of the 3 months, Amara looked at me across her desk and said, "Victoria, you have everything." I said, "I know." She said, "What do you want to do?" I said, "I want to close the gates." She said, "Tell me what that means." I told her. She was quiet for a moment. Then she said, "That is either the most elegant thing I have ever heard or a violation of about 17 different legal provisions." I said, "Which is it?" She smiled for the first time since I had closed her office door 3 years ago. She said, "It's the most elegant thing I have ever heard. And it's entirely legal. Because of something Raymond forgot." I said, "What did he forget?" She said, "He forgot whose name is on the operating agreement for MDG Holdings III. I said, "Mine." She said, "Yours. You are a co-manager of MDG Holdings III under the operating agreement, which means you have authority over the property management decisions for every asset in that entity, including 4417 Meridian Drive." I said, "Including the gate system." She said, "Including the gate system." I said, "And the utilities." She said, "And the utilities." I said, "And the household staff contracts." She said, "All of which are under the authority of the co-managers, both of whom must authorize any continuation of service, and one of whom has not been consulted about any of the current arrangements." I said, "Because she didn't know about the current arrangements." She said, "Because she didn't know? Until now." I said, "And now she knows." Amara said, "Now she knows." We looked at each other across her desk. I said, "Let's build the plan." Stop right here and subscribe to Black Diamonds. Right now, before this story goes one step further, hit that notification bell, because this channel exists for this exact story. For the woman who found the hotel charge and spent 3 years building instead of breaking. For the attorney who closed the office door and said, "What do you want to do?" For every person who has ever said, "I want to understand the full picture before I do anything," and then actually built the full picture. Subscribe. Drop your name and your city in the comments right now. Tell me where in the world you are watching from tonight. Tell me if this story is finding something in you. This community is real, and it is here for exactly this. Now let me tell you what the plan looked like. The plan had 4 elements, and it was executed over 48 hours, which is the amount of time Amara calculated we needed from the moment Raymond understood what was happening to the moment when his ability to undo what was happening had been sufficiently reduced that undoing it would require exactly the legal process that we had prepared for. The first element was the gates. As co-manager of MDG Holdings I had authority over the property management systems. The gate system at 4417 Meridian Drive was registered to the property management account. I contacted the gate system company on a Thursday evening and, identifying myself as the co-managing member of MDG Holdings III, the entity of record for the property, I requested a full system reset and reauthorization. This meant that every biometric registration, every remote code, every keypad sequence that had been programmed into the system was wiped and replaced with new credentials that I held. At 7:43 on Friday morning, the gates at 4417 Meridian Drive closed. And they stayed closed. The second element was the utilities. The electricity, water, gas, and telecommunications services at 4417 Meridian Drive were all billed to MDG Holdings III. I contacted each service provider on Thursday morning before the gate system call, identifying myself as the co-managing member of record and requesting a service review. I did not terminate the services on Thursday. I requested a 48-hour audit period during which service continuation would require dual authorization from both co-managing members. This was my legal right under the operating agreement. The services were placed in audit hold. The third element was the household staff. The property at 4417 Meridian Drive employed a housekeeper, a groundskeeper who was separate from the landscaping team, and a property manager who coordinated everything. All three were employed under contracts held by MDG Holdings III. As co-managing member, I contacted the property manager on Thursday afternoon and informed him that the property was undergoing a management review and that all staff activities were to be paused pending the review's completion, effective Friday morning. The property manager, who had presumably been told by Raymond that the property was a corporate entertainment asset, and who had no reason to understand the full context of the management review, complied professionally and completely. The fourth element was the filing. Amara filed the divorce petition on Friday morning at 8:15, 32 minutes after the gates closed. The petition was accompanied by a motion for a temporary restraining order preventing the dissipation of marital assets, a motion to freeze the operating accounts of MDG Holdings III pending a judicial review of the entity's management and asset allocation, and a detailed exhibit package that included 3 years of documentation, the complete picture of the property at 4417 Meridian Drive and its use, and a forensic accounting report prepared by a specialist Amara had engaged 6 months earlier that documented every corporate expense that had been allocated to the maintenance of a personal residence for a non-employee, non-business purpose. The forensic accounting report calculated the total amount of corporate funds that had been used to purchase, renovate, furnish, and maintain the property as a personal residence for Celeste Fontaine over 14 months as approximately $5,800,000, of which approximately $2,300,000 represented my 41% interest. That was the legal theory of the case: marital waste, breach of fiduciary duty as co-managing member, and fraudulent misappropriation of jointly held corporate assets. The filing was complete by 9 o'clock on Friday morning. By 9:15, Raymond's phone was ringing. I need to tell you about the phone call because the phone call is where the story becomes real in the specific way that stories become real when they stop being theoretical and arrive in the actual world. I was at my office at Ashford Legal Group when his call came in. I had been there since 7 because I had not slept much on Thursday night, not from anxiety, but from the specific wakefulness that comes when something you have been building for 3 years is finally at the moment of deployment, and the mind will not switch off because it keeps reviewing the checklist one more time. His name appeared on my phone screen at 9:17. I let it ring twice. Then I answered. I said, "Good morning, Raymond." He said, "Victoria, what is happening?" Not a question. A statement delivered in the specific tone that Raymond uses when he is managing something and is communicating through the management language that he is in control of the situation. I said, "I imagine you've received a call from your attorney." He said, "I've received several calls. The gate company, the utility providers, my property manager. And yes, my attorney who tells me that you have filed a petition." I said, "That's correct." He said, "Victoria, I need you to understand." I said, "Raymond, I need you to understand something. I have been understanding things for 3 years. I am done with that. What I am doing now is something different, which is acting on what I understand. And I want to be clear with you about the sequence of what happens next." He was quiet. I said, "The filing is a matter of public record as of this morning. The motion for the temporary restraining order will be heard by Judge Patricia Osei Williams, no relation to anyone you know, on Monday morning. The motion to freeze the MDG Holdings III operating accounts will be addressed at the same hearing. I have 3 years of documentation and a forensic accounting report, and a co-manager's legal authority over every property in that entity. I want you to talk to your attorney today, and I want you to understand that what has happened this morning is not the opening of a negotiation. It is the beginning of a process that has already been built completely." He said, "Victoria, the property is a corporate asset. I can explain," I said. "The property has been used as a personal residence for Celeste Fontaine for 11 months. The renovation and furnishing costs were billed to MDG Holdings III. The operating costs have been billed to MDG Holdings III for 14 months. I have the invoices, I have the contractor records, I have the staff employment contracts, I have the utility billing history, and I have the forensic accounting report that quantifies my 41% interest in every dollar that was spent." He said nothing. I said, "Talk to your attorney, Raymond." I ended the call. I sat at my desk. I allowed myself, for approximately 4 minutes, to feel the full weight of what had just happened. Not satisfaction in the punitive sense. Something more complicated and more honest than that. The specific weight of 3 years of building reaching the moment where the building is complete and the thing stands on its own and does not require you to hold it anymore. Then I opened my laptop. I had a client call at 10. Work does not stop because the most important thing in your personal life has arrived at its conclusion. This I have always known. This is part of what makes me who I am, and I will not apologize for it. The twist in this story is not the gates. I know that some of you have been listening and thinking that the gates are the twist, that the elegant legal maneuver of using co-manager authority to lock a man's mistress out of a corporate property is the reversal that the story has been building toward. It is a reversal, but it is not the twist. The twist is about Celeste Fontaine. Specifically, it is about what Celeste Fontaine did on Friday afternoon, 6 hours after the gates closed. She called my office. My assistant came to my door at 2:15 and said, "Victoria, there is a woman named Celeste Fontaine on the line. She says it's urgent and personal, and she says you will want to take this call." I stared at my assistant for a moment. Then I said, "Put her through." I want to describe what I was expecting. I was expecting anger. I was expecting accusations. I was expecting the specific emotional vocabulary of a woman who has been displaced from a comfortable situation and who is directing her displacement at the person she perceives as responsible for it. I was prepared for that conversation. I had thought about it. I knew what I was and was not going to engage with. What I was not prepared for was what actually came through the phone. Celeste Fontaine said, "Ms. Ashford Mensah. My name is Celeste Fontaine. I think you know who I am." I said, "I do." She said, "I need to tell you something. And I want to say first that I understand completely if you don't want to hear it and if you want me to end this call." I said, "Say what you have to say." She said, "I did not know he was married for the first 8 months." I was quiet. She said, "He told me he was divorced. He had documents, I saw them. They looked real." I had someone look at them and they were not real. I said, "Forged documents." She said, "Yes." She said, "When I found out the truth 8 months into our relationship, I told him I was ending it. He did not respond to that well. He told me that the property would be transferred out of my name if I left, except there was no property in my name. He had told me he was putting the property in my name when he purchased it. I only found out it was in the corporate entity when I had an attorney look at it 4 months ago. I said, 4 months ago. She said, "I have been trying to find a way out for 4 months. He has been, he is not. I want to be very clear about what I'm saying. He has been threatening me, not physically, financially. He told me that if I spoke to anyone about the property or about the relationship, he would ensure that I was prosecuted for fraud in connection with the interior design contracts I had with his company. The contracts were legitimate. I did real work. But he said he had documentation that could make them look like something else and that I should understand that." I sat very still. She said, "When the gates closed this morning and the property manager called me, I thought this might be the moment. This might be the person who has the power to make this stop. And I decided to call because staying quiet was not, I cannot stay quiet anymore." I said, "Celeste, I need to ask you something directly." She said, "Yes," I said. "Do you have documentation of the threats?" She said, "I have text messages. I have emails. I have a recording of a phone call from 3 months ago that I made because I was afraid and I wanted to have something in case I needed it." I said, "Where are you right now?" She said, "I'm at a hotel. I left the property this morning when the gate system failed. I took what I could carry." I said, "Which hotel?" She told me. I said, "Stay there. Do not go back to that property. Do not contact Raymond. I am going to give you a phone number and I need you to call it within the next 30 minutes. She said, "Whose number is it?" I said, "My law partner's. Her name is Dr. Amara Osai-Bonsu. She is going to help you." Celeste was quiet for a moment. She said, "Why are you helping me?" I said, "Because you called. Because you had the documentation. Because you made the recording when you were afraid, and that is exactly the right thing to do when you are afraid, and I am not going to leave that kind of courage unaddressed." She said, "I thought you would hate me." I said, "I am going to be honest with you. The feelings I have about this situation are complicated and they are mine to process. But what you just told me changes the legal landscape significantly, and what I do with a changed legal landscape is work. So call Amara. Do it in the next 30 minutes." She said, "Thank you." I said, "Don't thank me yet. Thank me when this is finished." She called Amara in 18 minutes. What Celeste Fontaine had was not simply evidence of Raymond's threats against her. What she had, as Amara recognized within the first hour of reviewing the text messages and emails, was evidence that Raymond had used his corporate position to create the conditions for what amounted to coercive control of a person he had initially deceived into a relationship. The forged divorce documents, the false promise of property ownership, the financial threats designed to prevent disclosure. When Amara called me at 5 o'clock on Friday afternoon, she said, "Victoria, the case just changed." I said, "Tell me." She said, "What Raymond did to Celeste Fontaine, taken together with what he did to the corporate entity and what he did to you, is not simply a divorce case with marital waste claims. It is a pattern of structured deception and financial coercion that touches criminal statute in at least 2 areas: the forged divorce documents and the fraudulent misrepresentation to Celeste regarding property ownership. She relied on his representation that the property was being titled in her name when making decisions about her own living situation. That reliance produced harm. That harm is actionable." I said, "You're talking about a fraud claim on her behalf." She said, "I'm talking about a fraud claim on her behalf, a coercive control claim, and potentially a referral to the state attorney's office regarding the forged documents." I said, "What does she want?" Amara said, "She wants it to stop. She wants the design contracts affirmed as legitimate so the threat he made against her evaporates. She wants to be able to leave without consequences. And she asked me to tell you this specifically, she wants to provide any testimony or documentation that helps you." I said, "She wants to testify." She said to tell you, "I have been quiet for 8 months because I was afraid. I am not afraid anymore." I said, "Then let's build her case alongside mine." The Monday hearing was the most efficiently conducted legal proceeding I have ever been involved in, which is saying something because I have been involved in a significant number of legal proceedings. Judge Patricia Osai Williams, who had been on the bench for 14 years and who had, in those 14 years, developed a specific quality of patience for cases involving the financial maneuvering of high-net-worth individuals in domestic disputes, received Amara's filing, reviewed the exhibit package, and looked up from the documents with the expression of a jurist who has just read something that is unusually complete. She said, "Counsel, this exhibit package." Amara said, "Yes, Your Honor." She said, "How long was this being prepared?" Amara said, "3 years, Your Honor, with additional material compiled over the past 48 hours. The judge looked at Raymond's attorney, a man named Gerald Whitfield, who was very good at his job and who was, I could see from across the courtroom, operating with the specific disadvantage of a lawyer who was given the case 48 hours ago and has not had time to fully understand what he is up against." She said, "Mr. Whitfield, your client's position." Gerald Whitfield said, "Your Honor, my client maintains that the property at 4417 Meridian Drive is a legitimate corporate entertainment asset and that its management has been entirely within the scope of normal business operations." The judge looked at the exhibit package. She said, "Mr. Whitfield, the forensic accounting report in the plaintiff's exhibit package identifies approximately $5,800,000 in corporate funds allocated to what the report characterizes as personal residential expenses over 14 months. Has your client provided documentation characterizing these expenses as business-related?" Gerald Whitfield said, "We are in the process of compiling that documentation, Your Honor." She said, "You are in the process." He said, "Yes, Your Honor." She said, "The plaintiff's co-manager authority over the entity in question is established by the operating agreement in Exhibit 7. Amara said, "Yes, Your Honor." Victoria Ashford Mensah has been a co-managing member of MDG Holdings, III, since the entity's formation. Her authority over property management decisions is explicit in the operating agreement. The judge said, "Then the actions taken on Friday morning with respect to the property management systems were within the plaintiff's legal authority." Amara said, "Entirely, Your Honor." The judge looked at Raymond. Raymond was in a suit that I recognized. He had worn it to a closing dinner 2 years ago. He had the specific expression of a man who is accustomed to being in rooms where his net worth generates a certain deference, and who is discovering that this particular room does not operate on that currency. The judge granted the temporary restraining order. She granted the freeze on the MDG Holdings, III operating accounts pending judicial review. She scheduled a full hearing for 30 days out and ordered both parties to submit complete financial disclosure within 14 days. She also made a comment from the bench that was not strictly required and that I have thought about many times since. She said, "The court notes that the plaintiff in this matter appears to have approached a complex and personally difficult situation with a level of preparation and legal precision that is," she paused, "not commonly seen in proceedings of this nature. The court takes no position on the personal dimensions of this dispute. But the court does take note of what has been built here and intends to give it the full consideration it has clearly been designed to receive." Amara touched my arm. I kept my expression exactly as I had practiced keeping it. I said nothing, but I felt it. Raymond's attorneys made 4 settlement offers over the following 6 weeks. The first was an insult dressed in legal language, which is what first offers frequently are in high asset cases. I declined it. The second was better. Still insufficient. I declined it. The third came with a request for a face-to-face meeting between Raymond and me without attorneys. I declined the meeting, but had Amara engage with his attorneys on the framework of the third offer. The fourth came 8 weeks after the Monday hearing, 2 days before the full hearing was scheduled. I want to tell you about the fourth offer because the fourth offer is where I saw most clearly what 3 years of building had produced. The fourth offer included a settlement of the marital estate that gave me 63% of the portfolio's current appraised value, which was my 41% interest plus an additional 22% calculated as the judicial remedy for marital waste and breach of fiduciary duty. Full ownership of our primary residence, the townhouse in the West End that I had selected and that I loved. A cash settlement of $4 million representing the quantified dissipation of marital assets. An agreement that Raymond would remove himself from any management role in MDG Holdings, III, for a period of 3 years, while a court-appointed administrator oversaw the entity's operations. And a provision that the interior design contracts between Celeste Fontaine and Mensa Development Group would be independently reviewed by an auditor selected by both parties and, upon the auditor's confirmation of their legitimacy, formally affirmed as valid completed business contracts. That last provision was not for me. It was for Celeste. I had insisted on it. Amara had told me I did not have to insist on it. She said, "Victoria, your leverage is complete. You can settle for yourself and Celeste can pursue her own case separately." I said. The threat he made against her was made possible because he was my husband and because the contracts were with his company. The threat evaporates when the contracts are affirmed in a settlement document signed by Raymond's attorneys. I am not leaving that thread unresolved. She said, "It will cost you leverage in the negotiation." I said, "I know, I have enough leverage, insist on it." She insisted. They agreed. The settlement was signed on a Thursday afternoon, 8 weeks, and 6 days after the morning the gates closed. I signed it at Amara's conference table with a pen that she had given me as a gift 12 years earlier when I passed the bar. A silver pen with my initials engraved on it, and I signed every page with the specific deliberateness of a person who has arrived at the end of something they built from the beginning. I need to tell you about the day after the settlement was signed. I went to the townhouse, my name alone on the deed as of the settlement, and I walked through every room, not with any particular purpose, just walking. The way you walk through a space that you are newly certain belongs to you in a way that is complete and uncontested. I made coffee in the kitchen. I sat at the kitchen table. My phone was on the table and I looked at it for a moment and then I called my mother. My mother is 71 years old and she has been widowed for 6 years and she has been through things that make my 9 years of marriage look like a relatively contained difficulty. And when she answered the phone she said, "Victoria, how are you?" Not a question, not exactly. The way mothers say it when they know. I said, it's done. She was quiet for a moment. Then she said, tell me. And I told her. For the first time, completely, the whole 3 years and the hotel charge and the mansion and the gates and Celeste's phone call and the hearing and the settlement. My mother, who had raised me to be careful and thorough and to understand that what is documented is what is real, listened to the whole story without interrupting. When I finished, she said, "The pen Amara gave you." I said, "Yes." She said, "I want you to keep that pen for the rest of your life." I said, "I was planning to." She said, "And I want you to understand something your father used to say." I said, "Tell me." She said, "He used to say that the difference between a person who survives something and a person who builds from it is not courage. It is the willingness to do the work before the crisis rather than during it." I said, "I know." She said, "You did the work before." I said, "Yes." She said, "That is your father's daughter." I sat with that for a long time. Celeste Fontaine's case was settled separately 4 weeks after mine. Her attorney, not Amara, a referral from Amara who specialized in coercive control and financial fraud, negotiated a settlement that included a payment from Raymond sufficient to cover 18 months of alternative housing. The formal affirmation of her design, contracts as valid and legitimate, and a non-disparagement agreement that ran in both directions. Raymond's attorneys, who understood by that point that the documentation Celeste held was the kind of thing that state prosecutors find interesting, were motivated to settle completely. She did not go back to the mansion. She moved to a different city and started over. I did not stay in contact with Celeste in the months that followed, not because of hostility, but because our lives were not designed to intersect, and because what had happened between us was complete in the specific way that things are complete when every thread has been resolved and nothing is left unaddressed. But I thought about her. I thought about the recording she had made when she was afraid, the specific courage of a person who does not know exactly how the recording will be used, but who understands that having it is better than not having it. I thought about the phone call she made at 2:15 on Friday afternoon when she could have stayed quiet and protected herself, and instead chose to call the one person she knew had the power to make things stop. I thought about what she had said. "I have been quiet for 8 months because I was afraid. I am not afraid anymore." That line matters to me, not because Celeste is a hero in this story in a simple or uncomplicated way. The situation she was in was real, and the fear was real, but the choices that led her there were also real, and I am not interested in erasing complexity for the sake of a neater narrative. But the specific act of making the call, of calling the person you know has reason to be your adversary, and choosing to tell the truth to that person, because the truth is what is required. That act is one of the most useful things I have seen in a long time. Truth, told to the right person at the right moment, is infrastructure. It builds things. Raymond Mensa. I want to tell you about Raymond in the aftermath, because the story would not be complete without it, and because accuracy requires that the aftermath be told honestly rather than with the simplifying satisfaction of a villain who receives exactly what he deserves in the way that dramatic justice usually delivers it. Raymond did not go to prison. The forged divorce documents were the subject of a state attorney's review, but the review did not produce charges, partly because Celeste chose not to pursue criminal prosecution as part of her settlement, and partly because the evidentiary threshold for criminal fraud prosecution in that jurisdiction is specific, and the case, while strong civilly, was more complex criminally. He also did not lose his company. Mensa Development Group continued to operate after the settlement. It is smaller now. The portfolio was divided as part of the settlement, and he no longer has access to the MDG Holdings III entity, while the court-appointed administrator is in place. His reputation in the Hartford development community is damaged in ways that have real business consequences. Several investors who became aware of the full picture through the public filing have quietly reduced their exposure to his projects. He will rebuild something. Men with his skills and his temperament and his $400 million in historical portfolio value do not simply stop building. He will find investors, and he will find projects, and he will find a version of his professional life that functions, and that function will be smaller than what it was, and that smallness will be, perhaps, the most sustained consequence he experiences. I have made my peace with that. Not because I have forgiven him in the way that forgiveness is sometimes described as a gift you give yourself, but because my peace with what Raymond's future looks like is not required for my peace with my own future, and my own future is the one I am building now, and it is more interesting to me than anything he does next. Let me tell you what I am building. Ashford Legal Group has expanded. We are 14 attorneys now, up from 11. We added a practice group focused specifically on high-asset domestic cases involving business entities and corporate structures, which is a practice area where, as I discovered through my own experience, and through the specific expertise I developed over 3 years of building my own case, there is significant unmet need and insufficient specialized counsel. Amara leads the practice group. I work on the cases that require what I think of as architectural strategy, the cases where the legal structure of a relationship has been deliberately obscured, and where finding the truth requires reading documents the way a developer reads a property, not for what they say on the surface, but for what they reveal when you understand how they were built. I am very good at this. I have always been very good at this. I just spent 9 years applying it to other people's problems before I applied it to my own. The townhouse is mine. I repainted the kitchen in October, 3 weeks after the settlement. Not because the previous paint was wrong, but because repainting a kitchen is a specific act of claiming a space, of saying this is mine now in the way that paint and color say it. And I had chosen a color, a deep, warm amber that in morning light is the color of something that has been built well and is standing solidly in the place it was built for. I make coffee at that kitchen table every morning. I sit with it for exactly 20 minutes before work begins. Those 20 minutes are mine. I want to tell you the broader thing now. The thing that this story means outside of the gates and the settlement and the forensic accounting report and the amber kitchen. There is a specific practice that women in complicated marriages develop, which is the practice of managing. managing the temperature of the room, managing the information that goes where, managing what is visible and what is not, managing the gap between what is and what is presented. I was a manager for 9 years. I do not say that as a criticism of myself. Managing is what the situation required, and I managed it. But I want to say something about the specific cost of managing, which is this. Managing takes the resources that could be building and redirects them toward maintenance. Every hour I spent managing Raymond was an hour that did not go into building my practice or building the documentation or building toward the life I am living now. I do not know how to recover those hours. I do know that the hours I spent building the documentation were not managing hours. They were building hours. And the distinction between managing and building is the distinction between a practice that keeps you in a situation and a practice that creates the foundation for leaving it on your own terms. Build, not managing. Building. Build the documentation when you have access to it. Build the understanding of what you own before you need to know it in a crisis. Build the relationship with the attorney who will close the door and say, "What do you want to do?" Build the knowledge of your own name on every document that matters. Build the plan before the crisis. Because when the crisis comes, and it came for me on a Tuesday morning with a hotel charge on a credit card statement, the difference between a woman who has been building and a woman who has been managing is the difference between opening a file that is already complete and starting from zero with the world on fire. I had a file. I had 3 years of a file. I had a pen with my initials on it, and I closed the gates. Subscribe to Black Diamonds right now. Hit that bell. Drop your name and your city in the comments below. Tell me where in the world you are watching from. Tell me if you are a manager who wants to become a builder. Tell me if you have a file. Tell me if you are starting one. Drop a heart if you believe that what is documented is what is real. Drop a heart if you have ever closed a door and said, "I want to understand the full picture." Drop a heart if you know whose name is on every document that matters in your life. Drop a heart for Amara, who closed the office door 12 years ago and said, "Come in," and sat across from me for 3 years while we built the case together. Drop a heart for Celeste, who made the recording when she was afraid and made the call when she was done being afraid. Drop a heart for the Amber Kitchen. Drop a heart for the Gates. This is Black Diamonds. We see you. We have always seen you. Next week on Black Diamonds, a woman who signed a prenuptial agreement that she was told was standard. Who spent 16 years building a fashion brand that became one of the most recognized in its category. Who discovered on the morning her husband filed for divorce that the prenuptial agreement she had signed contained a clause that she had not been independently counseled on, a clause that attributed the majority of the brand's intellectual property to the marital estate rather than to her personally. What her intellectual property attorney found when she analyzed the clause in the context of 16 years of business records. What the judge said when she saw the founding documents. And what happened when the brand's primary investors found out what was in the filing. That story is coming. Make sure your notifications are on. Because what those investors did when they read the filing changes the entire case. Until then, this is Black Diamonds. We see you. We have always seen you.